Hello and welcome to the Galeblade News. An imminent privacy ruling has the potential to cause chaos for companies which transfer data out of the EU. Legal experts are confident that a worst-case judgment will not be reached, but still warn of far-reaching implications. It involves a case against Facebook by a privacy advocate who objected to his information being sent to the United States. Thousands of companies rely on the existing measures, which are at risk. The case before the European Court of Justice is complex, but hinges in part on the concern that US law requires Facebook to hand over personal data to authorities such as the National Security Agency or FBI. Max Schrems, an Austrian national, lodged a case in 2013 after the Edward Snowden leaks revealed the extent of US surveillance. As a result, the ECJ overturned the long-standing safe harbour arrangement in 2015. In the aftermath, the US and the EU came up with alternatives, which Mr. Schrems challenged again, and this is now before the European Court of Justice. The concern has always been, when data leaves Europe, what's happening to it? It may not have equivalent rights, and individuals may not have equivalent protection, explained Jonathan Cooley, co-head of technology at law firm Clifford Chance. Most very large firms use what are called SCCs, pre-written non-negotiable contracts drawn up by Europe, which legally commit companies to uphold certain standards. An opinion written by an advocate general written in December recommended that SCCs remain, despite some concerns. However, the court is not bound to follow that recommendation and could still declare them invalid. Mr. Cooley said that was unlikely, but if it did happen, it would be pretty catastrophic. It would be an extreme and unwelcome decision, and I'm not just talking about technology companies, this is about every business. This would affect most countries outside the EU. It could, for example, affect a firm that wants to send human resources or payroll data to a head office outside the EU, or one which wants to store personal records in cloud storage located in the US. It would not affect strictly necessary data transfers, for example, emailing a hotel abroad to book a room, or visiting a website based in China. Mr. Cooley said a much more likely scenario is that SCCs are policed more closely in future, or considered on a case-by-case basis. Any decision is unlikely to affect the UK, even after the Brexit transition period ends at the end of this year. European GDPR, General Data Protection Regulation rules, have been adopted into UK law, and it is widely expected, although not certain, that a so-called adequacy decision will be granted, effectively saying that the UK's privacy rules are up to EU standards. That could change in future if the UK changes its laws to deviate from the current standards. So what do you think of this? As a citizen who's a member of the UK, who's moving away from the European Union, what does this mean for our data? Is it going to be protected? Are we going to have to treat the EU as the enemy now because the data transfer ruling is going to be one of those rules that either it has to be reciprocated or it's going to have to be adapted and changed? And how will that work with the interactions between us and the EU? Whatever you think, leave your comments down below. Like the video if you enjoyed it, and don't forget to subscribe.